Good morning, everybody, and thank you for the opportunity to talk about a topic which I think is extremely important and perhaps a little odd because we all know that the ANC has launched a process to amend the Constitution to allow expropriation without compensation, or EWC. But we have a concern that it will be possible quite soon for the government to achieve EWC even without a constitutional amendment. And this morning I want to sketch some of the circumstances in which we believe that will be possible. We think that there are four ways in which the government can achieve EWC without amending the Constitution. Firstly, under the Expropriation Bill of 2020, as I'll explain in a minute. This has various nil compensation provisions and a new clause 12.3, which we'll go over in a little bit more detail. It also has a very restricted definition of expropriation, and that matters because it opens the way for custodial takings without compensation, which I'll again explain, and also for regulatory expropriations without compensation. And then, in addition, we have the regulations dealing with the powers of the Valuer General under the Property Valuation Act of 2014. And those, we believe, could also result in zero compensation in certain instances. So let's look at these things in a little bit more detail. First of all, nil compensation under clause 12.3 of the pending Expropriation Bill of 2020. The government has now invited public comment on that with a deadline of the 10th of February 2021. The situation we're talking about here is where the state plans to take ownership of property. So we're dealing with what's called a direct expropriation, as opposed to indirect expropriations through custodial or regulatory takings. And where the state takes ownership, there are, according to the bill, 5 listed circumstances in which nil compensation would be payable. But that list is an open-ended one. It includes, but is not limited to, the 5 circumstances that it sets out. It is worth noting that Section 12.3 applies to land only, but there's also the question of fixed improvements on land. Buildings accede to the land on which they are structured. So will buildings effectively also be covered? And the bill is silent on that issue. According to clause 12.3, nil compensation may be just and equitable. First of all, where land is unused and is simply being held in the hope of a rise in market value. So if a developer buys land now, doesn't actually start developing it immediately, but hopes that in time the market value will rise and it will then be worth using it in some way or another, that in itself could entitle the state to take his land and pay no compensation. Secondly, where land is held by an organ of state, which doesn't need it for its core functions, which got it without paying for it, and which consents to the expropriation. Thirdly, where an owner has abandoned the land by failing to exercise control over it, even though he still has title to it. And that perhaps needs a little bit more explanation. What does not exercising control mean? We have the example of the Imanyandos, who were people living in KwaZulu-Natal on an old Lutheran mission, and they had built their homes on this land, but they found themselves forcibly evicted by the impi of a local chief and forced out of the property. The police were there at the time, but they did nothing to protect them. They simply stood by and let this forced eviction continue, after which their home was burnt and they were threatened with death if they tried to come back. Now, the Imanyandos did actually have title to that land, but of course they had lost control over it. They weren't able to exercise control over it. So under the bill, that would mean that the government would be able to expropriate the land and pay no compensation for it. We also have the situation in Johannesburg, for example, where many buildings in the inner city have been hijacked, and owners in many instances have found it impossible over time to evict the people who are now living illegally in their assets. And if you can't now afford to bring another eviction case, you are unable to exercise control over your building. So that presumably means that the government will be able to take it and pay no compensation. In addition, the clause talks about land with a market value which is equal to or less than the present value of any direct state investment or subsidy in the acquisition and the beneficial capital improvement of the land. So that's a lot of words. In essence, did the state help the owner to acquire and then to improve the capital value of the land? We have to note here that there has to be both elements must be satisfied, that the state must have helped you to acquire it, and it must also have done things which have increased the capital value of the land. So this would apply, for example, where a state has helped a farmer to buy and then to improve his farm. But it could also apply in other circumstances. Take, for example, a factory that's been erected on the East Rand, and that, of course, its value is boosted and helped by all the infrastructure in the vicinity, which has been created by direct state investments in electricity substations, in transport infrastructure, in the airport nearby, and so on. So that would seem not enough to entitle EWC, because the state wouldn't have done anything to help the factory owner acquire the land. But what if that factory owner had also received a manufacturing grant or incentive, which he had used in part to buy the land? Then it becomes more difficult to tell, and there is a possibility that that factory could be expropriated in return for nil compensation. Also relevant is a situation where the nature or condition of the property, this time not land, poses health, safety, or physical risks. And again, there are many rather old and rundown buildings in the CBD in Johannesburg, for example, where buildings which have not been adequately maintained could pose a fire risk, for example. And in that situation, it seems that a municipality or another organ of state could expropriate the building and then say that this qualifies for EWC, that it's just and equitable to pay no compensation in this instance. There's also a sixth possibility where a court is deciding on compensation under the Land Reform Labour Tenants Act. There again, it may decide that nil compensation is just and equitable. But that's a rather limited exception. It would apply only to labour tenants, people who have long time lived on farms where they don't have ownership, but they are generally allowed to run their cattle, grow their crops in return for giving a portion of the proceeds of their farming activities to the owner of the land. Much of the wording that's been used in this clause is highly uncertain. It would certainly be void for vagueness, because the wording used is so wide open that different officials and different organs of state could easily come to different conclusions as to the meaning of the words in different situations. We also have an extraordinary anomaly that an organ of state whose land is expropriated would have to give consent to expropriation without any compensation, but no other owner or holder is given that benefit. And in practice, the government has made a big point of saying that it's the courts that will decide on whether nil compensation is just and equitable, but in many instances they may never be given the opportunity to decide. The expropriation bill makes it very easy for a municipality, for example, after it's gone through certain preliminary steps, to issue a notice of expropriation, serve it on the owner, and then both the ownership and the right to possess the property will automatically pass to the municipality by operation of law on the date set out in the notice. And those dates could be set for within a day or week or so of the notice being served. So it could be that the whole process happens so fast that owners who have lost their homes, their business premises, or other property effectively feel they simply can't afford litigation. And so even though they have in theory a right to go to court to contest whether compensation should be nil, in practice that right will be an empty one. Then we move on to the definition of expropriation and the problems that this generates. According to the Expropriation Bill, expropriation means the compulsory acquisition of property by an expropriating authority, such as a municipality, provincial premier, and so on. And compulsory acquisition is significant because it comes directly from the ruling of Chief Justice Mogoeng in the Agri-SA case, which was decided in 2013. And in essence, there the Chief Justice said, whatever custodian might mean, it does not mean that the state has acquired and thus become the owner of the rights concerned. So in other words, said the court, the state's assumption of custodianship of an unused mining right was not an expropriation and did not qualify for any compensation. Perhaps just to give a little bit more background to the case to help explain all these concepts, in the Agri-SA case, what happened was that a mining company had an unused coal mining right, which it had bought for R1 million in 2001. Then the Mineral and Petroleum Resources Development Act, the MPRDA of 2002, came into force on the 1st of May 2004. At that point, the company had 1 year in which to convert its old order right to a new order one under the new legislation. But the fee for doing so was pretty steep. It was 1.5 million rand, and the company was busy going bankrupt, so it was unable to pay the fee. So after a year, it had failed to convert its old order right, which therefore ceased to exist, and the state thereby acquired custodianship of it. And the company claimed damages for expropriation. It said, we used to have a right, which we paid R1 million for, and now that right is with the state, and we believe that amounts to expropriation, and we should get compensation. The Pretoria High Court agreed, but when it came to the Constitutional Court, it was Chief Justice Mogoeng who placed great emphasis on the fact that the government had custodianship rather than ownership. And he came to the conclusion that the assumption of custodianship was not an expropriation because the state did not acquire the ownership of the mining right. It merely took over the custodianship of it. So where you have a deprivation which doesn't amount to an expropriation, then no compensation is payable. The definition doesn't directly say that what we're talking about is the compulsory acquisition of ownership, but this seems to be its thrust. And so the risk is that wherever the state takes property in a way that does not give rise to its compulsory acquisition of ownership, then there will be no expropriation and there will be no compensation. So let's think a little bit more about the custodial takings that could happen. As I said, it seems that no custodial taking will qualify as an expropriation because there will be no compulsory acquisition by the expropriating authority, but only the assumption of custodianship, which the Constitutional Court said is not enough. As Mogoeng said, the mere assumption of custodianship is different from compulsory acquisition. The ANC would, of course, like to take custodianship of all land. This is what it planned to do in the Agri-Land Bill in 2014, but let me note that that was actually applied only to agricultural land. So all farming land, in other words, all land which wasn't expressly zoned as urban, which wasn't expressly zoned differently, would have been vested in the state as custodian if that bill had gone through. It was abandoned, and in its new form, it doesn't have a custodianship clause right now. Then we had a land audit conducted by the state with a report in 2017, in which it was certainly indicated that the state would still like to take custodianship of all land. We also had a land official speaking at Davos in 2019 who made it clear that custodianship of all land remained the ANC's key goal. The Economic Freedom Fighters, or the EFF, have spelt out the implications of this. The title deeds will mean nothing, and everybody will need land use licenses, in other words, some sort of contractual agreement with the state in order to keep occupying the land which they currently own. And they will also, of course, have to pay land taxes or rents to the government, which could be so high as to make it difficult for many people to continue occupying their property. And the moment, of course, the state has full control, it might decide to terminate the land use license early. According to the EFF, these land use licenses would generally last for 25 years, but there'd be no guarantee that they would last for so long. At the same time, the legal position is not all that clear. Mokgweng in the Agri-SA case was dealing with an unused mining right, which is something rather different from the custodianship of land in general. It's arguable that because he said he was only dealing with the facts of the particular case, that he didn't lay down a general principle of law. But on the other hand, the ratio decidendi from that case seems very clearly to be that the assumption of custodianship does not amount to expropriation. And 3 judges did criticize his ruling and said that it would be an unwise thing to rule that the acquisition of ownership by the state was always needed for an expropriation. So the legal authority for what the expropriation bill says is not altogether clear, but what is clear is that the state would very much like to use this narrow definition of expropriation to open the way to custodial takings for which no compensation would be paid. And this definition would also be very useful when it comes to regulatory expropriations. So let me explain those a little bit. Here, the state does not take ownership, but its regulations reduce the normal powers and benefits of ownership. So let's take an example. Say the state sets a developmental price for platinum for compulsory local beneficiation here in South Africa. It doesn't want platinum to be exported in its raw state to other countries. It wants platinum to be beneficiated here. And partly to achieve that, it would say that Anglo Plat or any other platinum company can sell a certain amount of its platinum only at the developmental price set by the state to a local beneficiator, and that developmental price would be less than the global price for platinum. So the mining company would suffer a loss and should be able to obtain compensation under the usual and what is also the international law definition of expropriation, which includes indirect or regulatory expropriations of this kind. And the Mineral Council of South Africa has certainly indicated that they would want the government to pay compensation if they were to embark on this kind of regulatory expropriation and set maximum prices for platinum that are below the market price. But once we have this definition of expropriation in the expropriation bill, there will be, of course, no compulsory acquisition by the state, but merely a regulation which sets a maximum price. So it will be arguable, certainly by the state, that this means it does not amount to an expropriation and therefore no compensation has to be paid at all, because under our constitution, compensation applies only to a taking which qualifies as an expropriation and not to anything else. And there are many looming examples. For example, we increasingly see pressure from the government that companies should transfer 51% of their shares or their assets to BEE investors for often very much less than market value. And that would be another regulatory expropriation, but the state would not become the owner, rather the BEE investors would become the owner. So under this definition of what an expropriation consists of, it will be possible for the government to argue that there's been no expropriation at all, no compulsory acquisition by the state, and therefore the company that suffers a loss has no remedy. Then we come to the last possibility that we see, which is that of zero valuations by an official called the Valuer General, who is appointed by the government and is answerable to the Minister of Agriculture, Land Reform, and so on. And what matters here are the regulations that were gazetted in November 2018 under the Property Valuation Act of 2014. Those regulations laid down a formula which the Valuer General must use in making valuations. And his job is to assign a value to all property which is targeted for land reform. And I'll elaborate on that in a moment. The acting Valuer General came before the ad hoc committee, the one that is charged with amending the Constitution to allow EWC in March 2019. And there he talked about the formula which he applies, and he says it's a fixed formula, and it comprises this. The value which he assigns is current use value plus market value divided by 2 minus historical acquisition benefits and any state subsidies. And the critical part of that is really the current use value plus market value divided by 2. Because current use value is defined in the regulations as net present value, and then that is defined in the regulations as the difference between cash inflows and outflows on the date of valuation. And that's what makes net present value such a really difficult and slippery concept, because normally you would calculate net present value by looking at inflows and outflows over a period of 20 years or so, but the regulations demand that this should be done with reference only to the date of valuation. So take, for example, a suburban home, which has been targeted for land reform. That generally will have no cash inflows. It may have a certain number of outflows, but in essence, its net present value would simply be 0 because it's not a business with inflows and outflows. So if you apply the formula, say the market value of the home is 2 million, but its current use value is only 0 rand. So according to the formula, you take 2 million plus 0 rand, and then you divide by 2, and you come to a value of only 1 million, which is half of market value. And this, of course, is still not 0 compensation, but there are other provisions in the regulations which could bring you to that situation. And this is where the acquisition benefits come in. Say the owner inherited the home, which was then worth 800,000. So 800,000 is her acquisition benefit, but it has to be increased in line with inflation, and say it's equivalent to 1.8 million now. Then you go back to the formula. You have to subtract 1.8 million from the 1 million that you earlier calculated. So the value is now minus 800,000. And in this situation, of course, it's EWC that effectively applies, even though it's not called that. And the valuer general has the job of putting a value on all land and accompanying movables which have been identified for land reform. So this would presumably include any fixed improvements that accede to the land. And in the case of a farm, it would include cattle, for example. It would include tractors and other equipment. And the formula becomes a little bit more complicated where there are movables to take into account as well. But essentially, the same approach will apply. The wording that's been used in the regulations is inconsistent with the Act. In other words, when the minister gazetted the regulations, he was acting ultra vires the provisions of the Act. And it's probably also unconstitutional, because the definitions which are used in the regulations are against the definitions which are used in the property clause, and so that inconsistency makes for unconstitutionality. So what can one do about these looming threats, the possibility of expropriation without compensation, even without the Constitution being changed? And it seems to me that there are various possibilities. We have a damaging precedent in the Glenister 1 case, where the Constitutional Court said that the courts must not interfere with the legislature while it's still busy passing legislation. It must wait until the legislative process is completed and then consider whether there is any conflict between the laws adopted and the Constitution. So that would suggest that no possibility of litigation applies until the expropriation bill has been enacted. On the other hand, there is Section 38 of the Constitution, which gives people the right to go to court to stop looming threats to various guaranteed rights. And that would seem, despite Glenister 1, to give people the opportunity to go to court right now to say that the expropriation bill is inconsistent with various provisions in the Constitution. And we believe that it's in conflict with Section 25, which is, of course, the property clause, with Section 26.3, which says that nobody can be evicted from their home without a prior court order. Yet often under the expropriation bill, there's a risk that people will lose the right to possess their homes before any court has given any order on the validity of the expropriation, and that they would then be vulnerable to eviction without a court order. Also to Section 33, which deals with just administrative action, the possibility that people will lose ownership and the right to possess their properties within a few weeks of a notice of expropriation being served on them and before any compensation has been paid, again shows that this goes against arti alteram partem. It goes against the principle of nobody should be a judge in their own cause, nemo judex in sua causa, and so it's contrary to Section 33. It's also contrary to Section 34, the right of access to court, because in many instances people will lose their property to expropriating authorities without the chance ever to have a court adjudicate on whether the expropriation is really valid, and also on whether the amount of compensation, whether it's nil or something higher, is actually just and equitable. You can also, if you feel too worried about Glenister 1 and its ruling that one must wait until the legislative process is over, you can do just that, and after enactment, you could challenge the constitutionality of the expropriation bill, possibly on procedural grounds, which might indeed be feasible. It all depends, for example, on whether the public consultation process is inadequate. In 2015, the then expropriation bill was sent back to Parliament by the President precisely on that ground. So there's always that possibility. It could also be challenged on substantive grounds. In other words, that the expropriation bill is inconsistent for the reasons that I've given with sections 25, 26.3, 33, the right to administrative justice, and 34, the right of access to court. And on that basis, one could have the expropriation bill struck down as unconstitutional before it can come into effect. It's also possible right now to challenge the value of general regulations as being out of violates the Act, and organised agriculture has been making moves in that direction. But critically speaking, though we must use the courts as a weapon where this is possible, what is most vital is to keep waging the battle of ideas, to keep explaining to people how damaging it will be to all South Africans, and particularly to the Black South Africans who were barred from property ownership in the past and have now acquired property ownership in a big way, though not always backed up by title deeds, yet now stand to lose what they have gained, ironically under an ANC government. We have to keep on explaining the risks, and importantly, we need to reframe the debate. The ANC has been very successful in the context of EWC, for example, as painting this as a land reform measure. We need to bring out the fact that the definition of property in the expropriation bill, like the definition of property in the Constitution, expressly says that property is not limited to land. So we're talking about nil compensation for properties of various other kinds, including potentially mining rights and the like. We also need to show that it's not EWC that's going to make a success of land reform, but rather proper progress on all the other barriers to success which now pertain, particularly the corruption and the inefficiency which plagues the process. In addition, we need to try and change the balance of forces. The ANC is well aware that it can only proceed with this kind of legislation when the balance of forces or the surrounding circumstances indicate that it's not going to get a great deal of pushback. So the more pushback it sees, the more likely it is to reconsider. And our job is to ensure that the pushback is as strong as possible so that the ANC is given reason to draw back from these highly damaging proposals. Thank you.